Renato ACASIO, and today we are going to talk about the introduction to legal writing. According to Judge Prettyman, the lawyer's greatest weapon is clarity, and its whetstone, succinctness. Legal writing is the written output of lawyers. It covers a broad and varied range of paper, contracts, letters, pleadings, brief opinions, to name a few. The foremost aim of legal writing is to communicate, to write in such a way that the reader understand the way we want to say it. According to the book of Hill Marvel, Tabucanon, in this chapter, our purpose is to define legal writing, its type and categories, and be able to name example within each category. Now, before we go to the legal writing, let's first define what is legal writing. Legal writing is the kind of writing that lawyers, law professors, judges, and other workers in the field of law use to express their legal rights, obligations, and opinions. It is generally of three types and fall under two broad categories. This kind of writing involves the analysis of facts, patterns, and presentations of arguments in documents in such as legal memoranda and briefs. One form of the legal writing involves drafting, a balanced analysis of a legal problem or issue. Now, there are three types of legal writing. That's informative, persuasive, and functional. Let's discuss each. Now, when we say informative writing, it conveys information on an issue involving the law or a person's legal rights. This type of writing does not take sides. Its goal is objective communication by predicting the law's path vis-a-vis a set of facts regardless of who is involved. Example of which is memoranda, letters to clients, and statements of facts in brief. Now, persuasive writing, it aims to convince the reader to accept a certain viewpoint. Here, the writer argues for a particular side or perspective. He is expected to use available legal tools to support his thesis, which may be piece of evidence offered in court, sections of the law, decisions of the Supreme Court, and opinion of legal authorities on a subject. Examples: academic legal writing, motion, pleadings, and argument section of a brief. Persuasive writing is a written advocacy. Your aim is to persuade written to support your client's legal position and move your reader to agree with the legal conclusion that will benefit your client. To be persuasive writer, you must keep two primary principles. That is the perspective and the audience. Now, the last type of legal writing is the functional writing. Functional writing is one written for a specific use or result in law. These are deeds, wills, contracts, or drafts of laws and ordinances that legally bind of those involved. Some specific format, ceremonially, or legal requirements may be present in this type of writing. This type of writing need not be analytical or persuasive. It is enough to be accurate and complete, yet understandable. So that is the first part of the introduction to legal writing. Our group mate TRIXIA, JORGIA, AGANAN will discuss to you the two broad categories which will give you a good foundation on legal writing.
As future practitioners of law, we will be composing various kinds of legal writing for different purposes. In identifying these writings, let us get familiar with the two broad categories of legal writing. Legal writing is composed of two broad categories. One is legal analysis, which later on we will be classifying into two, namely predictive analysis and persuasive analysis. The other category is legal drafting, which is the functional type of legal writing. Under the first category, legal analysis, we have predictive analysis. A predictive document belongs to the information type of legal writing and deals with a legal question in three ways. First, we have analysis, where the facts and law are analyzed and studied closely. Given the facts, a lawyer will apply the law or a jurisprudence as a basis, and they are also interpreted according to the meaning of the law. Next, we have prediction, which is the outcome of the legal question. So a lawyer does not necessarily give a positive prediction all the time. A prediction can be positive or negative. Lastly, we have recommendation, where the writer gives his advice or recommendation based on the facts and the law as to the best line of action under the circumstance. An example of these is an opinion memorandum written for senior partners and legal opinion letter for clients. The opinion may be for or against the question the client has raised. Another type of legal analysis is a persuasive analysis. Coming from its name, a persuasive document attempts to convince or persuade a judge, an arbiter, or any other deciding authority to decide the case in favor of the writer's client. So this is basically one you present to the court in order to persuade your case. Best example of these are pleadings, motions, and briefs. The second broad category of legal analysis is legal drafting. So what is legal drafting? Legal drafting is a functional type of legal writing. Here, the writer creates a legally binding document or uses an already available template found in Legal Forms Handbook. Among the examples are contracts, deeds, like sales of mortgage, wills and testaments for private persons, and laws, regulation, and ordinance, which bind the public in general. Legal drafting requires no legal authority. There is a separate subject in the law curriculum named Legal Forms, which deals with legal drafting.
Hello, Attorney Alex and blockmates. Now, I'll be sharing to you some of the commonly used terms in legal writing and how it is usually being done by lawyers in their profession. First is memorandum. It is a paper that explains and summarizes specific points of law for a judge, for another attorney, or for a client. As you can see on your screen is a sample of a trial memorandum for a plaintiff filed in Regional Trial Court, Cebu. This trial memorandum includes statement of facts, statement of issues, and the corresponding arguments or discussion for this particular case. Lastly, it also indicates the prayer, or in legal jargon, it is the specific request for judgment, relief, and/or damages at the conclusion of a complaint or petition. We now come to the second term, which is pleading. It is a formal presentation of claims and defenses by parties to a lawsuit. These are the specific papers by which parties to a lawsuit present their allegations in proper form, specifically the complaint of a plaintiff and the answer of a defendant, plus any additional responses to those papers that are authorized by law. In here, you can see some samples of pleadings, which are complaint filed by the plaintiff and answer, which is on the part of the defendant, filed in various trial courts here in our country. The third term is motion, which is a written or oral application made to a court or judge to obtain a ruling or order directing that some act be done in favor of the applicant. One of the most common example of this is motion to dismiss, wherein it asks the court to dismiss an action because the initial pleading or complaint fails to state a cause of action or claim for which the law provides remedy. As shown here in the slide are other examples of motion like the motion for reconsideration and motion for summary judgment. We now go to the fourth term, which is a brief. It is a written document that an attorney draws up for a party in a lawsuit or by a party himself or herself appearing pro se that concisely states the issues, facts, relevant laws, and arguments. We can now see here some parts of the brief as I have stated earlier. The issues of a lawsuit, the facts that bring the parties to the court, relevant laws that can affect the subject of the disputes, and arguments that explain how the law applies to the particular facts so that the case will be decided in the party's favor. The last term that I'll be discussing is the appellate brief. It is a writing that must be filed with an appellate court so that the court may evaluate whether the decision of the lower court should be reversed because of some error that occurred during the trial. The essential elements of an appellate brief are highlighted in the screen right now. Now we have two kinds of this. The appellee's brief will argue that the lower court acted properly in its judgment and will be requesting its affirmance. On the other hand, the appellant's brief will attempt to convince the court to reverse or vacate the lower court's judgment.
Let us now proceed with the second chapter of legal writing, which is simplicity. The goal is to be able to write simply. Legal practitioners in their writing must use shorter words and sentences, be able to get to the point soonest, minimize connective words and pronouns, and use understandable words instead of highfalutin words. They must also avoid word expressions, cliches, tautology, and convoluted words and construction. They must avoid elaborating on the obvious and being repetitive. Legal writing must have these three elements: simplicity, clarity, and persuasiveness. Christopher T. Lutz once said, "You're not less of a lawyer for being understandable." To illustrate, let me introduce to you two honorable lawyers named Attorney Suave and Attorney B. Cool. We will see and assess their writing and some of their work. First, let us now read the petition for adoption prepared by Attorney Suave. The petitioners, through their counsel and unto this honorable court, most respectfully allege the following to wit: that petitioners are both of legal age, Filipinos, faithfully and devotedly married to each other before the law and the Catholic Church, whose humble abode is at number 37 Lago Drive, San Jose, Zamboanga City; that they desire to adopt a minor child named Carmela Rojas, who they have raised and treated as their own, who is a female, 3 years of age, Filipino, and who is also staying with them at number 37 Lago Drive, San Jose, Zamboanga City, because they wanted to adopt the child. Now, let us look at the petition written by Attorney Bicol and compare it with the first example. The petitioners, through their counsel and unto this honorable court, most respectfully allege the following to wit. Petitioners are both of legal age Filipinos, married to each other, and residents of number 37 Lago Drive, San Jose, Zamboanga City. Petitioners desire to adopt the minor child, named Carmela Rojas, who is a female, 3 years of age, Filipino, and likewise residing at number 37 Lago Drive, San Jose, Zamboanga City. Can you tell which writing is better? In this example, Attorney Bicol has written with simplicity. Simplicity in writing means to write plainly and simply. Attorney Bicol has observed the rules on economy of expression and has written with clarity. It is straight to the point, avoids unnecessary adjectives and adverbs, and repetitive thoughts. According to William Zinsser in his Tips on Writing, clutter is a disease in writing. The secret of good writing is to strip every sentence to its cleanest component. Another example is a complaint for a plebeian. Let us now read what Attorney Suave has written. The herein plaintiff is willing and ready to give a bond pursuant to the rules of court executed in favor of the defendant in the instant case in an amount double the valuation of the subject personal property above described, and for the return of the same property if the return thereof be adjudged, and for the payment to the same defendant of such amount as he may recover from the plaintiff in the herein action. So, did you guys understand what we have just read? This sentence made by Attorney Suave contains 76 words to express 7 separate thoughts, whereas a good sentence typically contains one main thought in less than 25 words. It is preferable to express only one and at most two of such thoughts in a statement. Meanwhile, let us now read what Attorney Bicol has written. The plaintiff is willing to give a bond double the value of the property. He likewise undertakes to return the property to the defendant or pay him such amount if adjudged to do so. Attorney Bicol has expressed his statement better because he used shorter sentences which made his writing easier to understand even if it's read only once. Shorter sentences aid the reader's concentration and memory. Also, in Attorney Bicol's writing, the omission of unnecessary words contribute to the economy and simplicity of his expression. The next reporters will discuss the next topic, which are the rules that can help you achieve those qualities in your legal writing. Thank you very much for listening.
Thank you, Kate. We are now done with the elements of legal writing. Next is the rules. As previously mentioned, the purpose of simplicity in writing is to be able to write simply. We are expected to use a short sentence. As a rule, the following must be observed. The first one is to avoid wordy expressions. Next is to avoid elaborating the obvious, get to the point, avoid tautology, eliminate certain dispensable words, and lastly is to minimize the use of connectives and relative pronouns. Avoid wordy expressions. Simpler instruction is preferred to rather than using too many words to express an idea. In this picture, we can see a sample wordy expressions from the left and its equivalent on the right when we can have it short or brief. To give you an illustration, let's go to the next slide. The cars were bought for the purpose of starting a taxi business. This is an example of a wordy expression. Again, the purpose of simplicity in writing is to be able to write simply, so we are expected to use a short sentence. Instead, to make it simple, we can say that the cars were bought to start a taxi business. Remember that conciseness, it must be concise. It must be brief. So, in order to communicate, do it with dispatch. So, if the judge can be convinced by 10 pages of argument, there is no need to write a pleading of 60 pages. Remember that it is the argument that are weighed, not the paper on which they are printed. Be concise. Avoid elaborating the obvious. This means not expanding or restating the obvious with information he already has. Let's take a look at this illustration. Annie Bantug's two sons, Kenneth and Julio, play judo. This is an example of a wordy expression, but we can still make it simple. We know for a fact in his writing that Kenneth and Julio are the sons of Annie. So, avoid elaborating the obvious. Instead, we can write Annie Bantug's sons, Kenneth and Julio, play judo. Next rule is get to the point. A sentence should contain no unnecessary words or must omit unnecessary preliminaries. Here is an illustration under this rule. For wordy expression, we are very proud and happy to announce that our office won the gold championship this year. Remember that the goal is to reach the main or most important idea of something that is said or written. Meaning, a sentence should contain no unnecessary words and must omit unnecessary preliminaries. So to make it simple, we can write, our company won this year's gold championship. Get to the point. Another rule is to avoid tautology. In order to avoid using tautologies, pay careful attention to the logic of what you are writing. Often beginning writers cannot see what they have written as objectively as other people and may not notice tautologies. So you have to practice reading your writing as if you were someone else. This means doing away with needless repetition of an idea expressed differently. So let's take a look in this illustration. Please voice out your opinion. This is an example of a word expressions under this rule. Again, pay careful attention to the logic of what we are writing. So to make it simple, we can write, please voice your opinion. Eliminate certain dispensable words. Wordy sentence may be made shorter by eliminating there, that, which, who is, as to, it, or one. For example, under word expressions, there were 8 members of the faculty who attended the meeting. When we can use it on a simple sentence to make it brief or concise, we write 8 members of the faculty who attended the meeting. See the difference? The next one is to praise the fact that is often unnecessary. The word expression, for example, calling your attention to the fact that I care for you. When we can use it in a simple way, I am reminding you because I care for you. The next one is a phrase may be converted to a word or be eliminated together. Under word expression, as per our telephone conversation, when we can say or we can write under a simple sentence, as we said or as we discussed, with the exception of example. Lastly is to minimize the use of connectives and relative pronouns. Connectives may be coordinate conjunctions such as and, but, which join clauses of equal rank, or subordinate conjunctions such as, because, if, that, though, which connect to the principal clause, a clause of a minor rank. Irrelative pronouns or relatives relate to an antecedent and introduce a qualifying clause. Let us now read the sample illustration prepared by Attorney Suave. Mr. M explained that W Bank's building renovation loan is conditioned upon a valid and subsisting coverage of a fire insurance and complete and up-to-date payment of realty taxes, and that in the light of X Insurance's recent bankruptcy, many of that would be W Bank's borrowers were genuinely and thoroughly concerned, as X Insurance is the only insurance firm in town. For Attorney Suabe, sample illustration is a single sentence composed of loose clauses joined by connectives. It may be recast in simple sentences. The result preserves the original thought flow of the writer without taxing the reader to go through great lengths. If anything, clarity and conciseness is achieved. For Attorney Bicol, sample illustration, Mr. M explained that W Bank's building renovation loan is conditioned upon a fire insurance coverage and updated realty tax payments. The recent bankruptcy of X Insurance caused concerns to potential borrowers. It is the only fire insurance firm in town. Attorney Bicol's sample illustration is the improved version of the use of connectives and relative pronouns.
Hi, this is Van. Actually, this is just a continuation on Mr. Ermenda's discussion. We are going to show you an illustration about the rules under simplicity and legal writing. Aside from the examples provided earlier, we have here an example of a wordy and concise pleading created by Attorney Suabe and Attorney Bicol. So let us see first a pleading written by Attorney Suabe. Okay, so the pleading of Attorney Suabe goes like this. Plaintiff, through counsel, alleges that plaintiff is of legal age with residence at 2024 Santa Cruz Proper, Naga City, Philippines, and the defendant's identity and address are unknown to plaintiff at the present time. That on 3rd of October 2021 at around 4 p.m. in the afternoon in the city of Naga, Philippines, defendant, while driving a blue Jeep car with plate number 1000 Manila, did then and there, through recklessness and imprudence, hit plaintiff's automobile, which is a Ford 2015 model, two-door sedan with plate number 2000, while said Ford automobile was parked at Ateneo Avenue in the middle of P. Santos and Mother Francesca streets, thereby smashing the radiator grille and the left front mudguard of said car and seriously damaging the door of the same, as result to which plaintiff suffered damages in the amount of 16,000 pesos. The defendant sped away and tried to depart quickly after hitting plaintiff's car, which caused a lot of damage into it, rendering it impossible for plaintiff to get the name of said defendant for the reason that it sped off so quickly. But plaintiff did succeed in identifying the make and color of the defendant's Jeep, even though the car is fast, as well as the number of the same. Wherefore, it is prayed that judgment issue ordering defendant as soon as his identity is ascertained to pay to plaintiff the sum total of 16,000 pesos plus costs. Alright, so you can see on your screen the pleading created by Attorney Suabe. And actually, we highlighted the unnecessary words for you to compare it to Attorney Bical's pleading later. But it's not actually too hard to tell that it's way too wordy, and there are words that should have been omitted, and he basically did not follow the rules discussed earlier. Say, for example, 4 p.m. in the afternoon. That's already tautology. He should have said 4 o'clock in the afternoon instead of 4 p.m. in the afternoon. Again, we can omit words to avoid redundancy and unnecessary repetition. Another one is sum total. That's wordy. You should have used just the word sum alone or just total alone. There are also dispensable words to the point that he'd already lost the idea or the narrative. But anyway, let's proceed to Attorney Bical's work and let's see the difference between their pleadings. Alright, so the pleading of Attorney Bical goes like this. Plaintiff, through counsel, alleges the plaintiff is of legal age with residence at 2024 Santa Cruz Proper, Naga City, Philippines, and the defendant's identity and address are unknown to plaintiff at present. That on 3rd of October 2021 at around 4 o'clock in the afternoon in the city of Naga, Philippines, defendant, while driving a blue Jeep car with plate number 1000 Manila, did then and there, through recklessness and imprudence, hit plaintiff's automobile, a Ford 2015 model, two-door sedan with plate number 2000, while said Ford automobile was parked at Ateneo Avenue between P. Santos and Mother Francesca Streets, thereby smashing the radiator grille and the left front mudguard of said car and seriously damaging the door of the same, as a result of which plaintiff suffered damages in the amount of 16,000 pesos. That the defendant sped away after hitting plaintiff's car, rendering it impossible for the plaintiff to get the name of said defendant, but plaintiff did succeed in identifying the make and color of defendant's Jeep as well as the number of the same. Wherefore, it is prayed the judgment issue ordering defendant, as soon as his identity is ascertained, to pay to plaintiff the sum of 16,000 pesos plus costs. Alright, so if you noticed, contrary to what Attorney Suabe has created, you can see that Attorney Bical stick to the rules discussed earlier. So he avoided wordy expressions and avoided elaborating the obvious. He got to the point and avoided tautology. He eliminated some indispensable words and minimized the use of connectives and relative pronouns. So if you can notice as well, his pleading is organized. It's simple, it's plain, it's concise and easy to understand. He avoids personal narratives that can take a long time to go to the main topic. He also avoided redundancy that can make a sentence long and irrelevant, and he omitted unnecessary words. So that's basically the proper way on how to write a pleading following the rules on legal writing. So yeah, that's it for my discussion. I hope you learned something today. Have a good one.
Here is the summary and writing tips on obtaining simplicity. First is to be direct. Write directly towards your goal. In aiming for simplicity, you have to set aside using jargons and highfalutin words. Also, avoid lengthy sentences which would be hard to read and comprehend. Short sentences are your key to plain and simple writing. Second is to always remember that the clear writing comes from clear thinking. It is important to visualize what you want to express and say before you write. A crowded mind will reflect to your output. Thus, to clear your mind from extra thoughts that might mess your writing, it would help to have a clear direction of thoughts, or if not, at least an outline of your main points before writing. And lastly, be natural. Write with your own voice. This will make your thoughts and language come out fluidly and your output easier to comprehend. As you write, Always remember that the main objective of writing is to express and not to impress. And this, with being yourself, will be easier to achieve. Here is an example of a simplified output earlier of Attorney Bicol from Attorney Suabe. There are words that are not actually necessary for the writing to be understood. Here, highlighted in red, are the words removed to simplify the sentences. Adverbs devotedly and faithfully were removed since it is enough to say that they are married to each other. Also, see humble abode was omitted. It only lengthens the sentence. And in its absence, the context will still be understood. In the second sentence, some phrases were removed. It only appeared to stand as a reiteration of their desire to adopt Carmela, which was already mentioned in the beginning of the sentence. So that concludes the chapter.